Hello, my name is Lauren Antone, and I'm the Senior Marketing and Events Coordinator at MAR, as well as the producer of our free webinar series. Our webinar today is Disclosure versus Confidentiality, an Agent's Conundrum. This webinar will cover claims and theories of liability against realtors. These claims will include breach of fiduciary duties, fraud, and negligence, and will offer practical tips for avoiding liability, including drafting considerations for purchase and sale agreements, and ethical considerations during your engagements. After our live session, the webinar will be recorded and added to our website at marealtor.com under webinars. If you have any questions throughout the session, please type them in the bottom of your chat box on your screen, and we'll hold a Q&A afterward. Our presenter today is Bob Stetson. Bob, a partner in Bernkopf Goodman's litigation group, combines hard work, preparation, and dedication to deliver cutting-edge legal services, representing clients in negotiations, disputes, and inside the courtroom. Bob's clients, which range from real estate developers, general contractors, and business owners to residential property owners, say Bob is their go-to guy because he's thorough, poised, and comes up with a clear plan of attack. Now, over to Bob.
Thank you, Lauren, so much for that nice intro, and thank you for having me. Good morning, everyone. As I'm sure all of you know better than me, home sales rose in 2020 to the highest level since before the Great Recession. Although home sales have begun to slow for a variety of reasons, increased cost of building materials, construction labor shortages, increased mortgage interest rates, the number of home sales is still expected to exceed 6 million this year. An estimated 88% of these sales went through a real estate broker or agent. And there are an estimated 2 million real estate brokers or agents in the United States. Given the sheer mass of transactions involving each of you, it is no surprise that home sale disputes sometimes end up in court, and that many of these cases involve brokers or agents like yourselves, oftentimes the perceived deep pocket in the situation. This presentation is designed to help you understand and hopefully avoid these liability issues, with a particular emphasis on the countervailing duties of disclosure and confidentiality. As Lauren mentioned, this presentation is called Disclosure versus Confidentiality, an Agent's Conundrum. Next slide, please. Thank you all for joining me. Again, my name is Bob Stetson. Lauren gave me a great introduction, so I won't go any further, but my contact information is listed here, including my cell phone. Please feel free to reach out to me anytime with follow-up questions. I would love the opportunity to get to know each of you. I know you are all busy, and again, I'm grateful for your presence. So in the event you have to sign off early, I've included a summary of the main points of the presentation here. It's a basic roadmap along with references to some of the main issues that tend to arise in the broker-agent liability context. We have breach of fiduciary duty claims. The most common of those is self-dealing, where the agent has some sort of self-interest in the transaction. Fiduciary duty issues should also be considered in dual representation situations. And with respect to pocket listings, dark listings as they're sometimes called, and have been a hot topic in the real estate world in recent years. Next, we have fraud or misrepresentation. The examples of misrepresentations on real estate transactions are innumerable, anything from misstatements about square footage to misleading statements about neighboring pig farms. Talk about one of those. And we'll get to some of the other examples as well later on. Not every statement even if inaccurate, qualifies for treatment as fraud. The most typical example of one of these exceptions is sales puffery. Then we have exculpatory provisions. These are your as-is type clauses that are typically in purchase and sale agreements. These can sometimes insulate agents and sellers from negligent misrepresentation claims, but not necessarily for claims of fraud or violations of Chapter 93A, the Massachusetts Consumer Protection Act. We have negligence. Generally speaking, there is no liability for simply passing along information received from a seller. This is why, for brokers, mandatory disclosure forms can be such a useful tool. Unfortunately, Massachusetts is only one of 3 or 4 states in the country that does not impose some form of mandatory disclosures in home sales. Either way, the agent's reliance on whatever information it receives from the seller and passes along must be, quote, reasonable under the circumstances. And we have Chapter 93A. Did the agent or broker commit an unfair or deceptive act with respect to the sale? The Consumer Protection Act, Chapter 93A, presents a particularly compelling example of the tension between an agent's duties of confidentiality on the one hand and disclosure on the other hand. Because under Chapter 93A, arguably, you all have a duty to disclose latent defects in the home that you know about, while at the same time owing fiduciary duties of confidentiality to your client and to try to get the best possible price for your client. And lastly, we'll touch on errors and omissions insurance, which applies to claims arising out of, quote, professional services. Next slide, please. In any discussion about agent and broker liability, the place to start is, what is the nature of your role in the real estate transaction? That should provide the baseline for examining the various liability theories. To that end, I've included here a quote from a court decision that I think sums up your role pretty well. And I'm going to read it. Real estate brokers and their agents hold themselves out to the public as having specialized knowledge with regard to housing, housing conditions, and related matters. The public is entitled to and does rely on the expertise of real estate brokers in the purchase and sale of its homes. Therefore, there is a duty on the part of real estate brokers to be accurate and knowledgeable concerning the product they are in the business of selling. That is, homes and other types of real estate. Sounds like a simple idea. You should be accurate and knowledgeable in conducting your business. But what does that mean in practice, and how can things go wrong? Let's take a look at a real life agent-buyer interaction.
Wonderful. Well, I do have to explain something to you. Upstairs in the master bedroom, we did find an entity, and it was an incubus. I know you're wondering what that is.
I have no idea.
Yeah. Well, that is a pretty evil spirit, actually. I know it sounds awful, but we're going to have it taken care of. We're going to have an exorcist come in and get rid of it.
This is real, really? Like,
I know. I know. Isn't that unbelievable that things like this happen in this world? So trust me, come back in a couple of days and you'll see it's a big difference.
I just absolutely love this realtor, and I've seen this clip so many times, it makes me laugh every single time. You'll notice that this is a Comedy Central clip from the show Nathan For You, but it is a real life interaction, and it sort of highlights, albeit to perhaps absurd effect, the agent's dilemma. What do you need to disclose? Let's start with some history.
Wonderful.
Real estate agents and brokers did not exist before the mid-19th century. Before this time period, real estate transactions had typically been handled by lawyers and the buyers and sellers themselves. Trade groups for agents and brokers started popping up around that time, around the 1850s, the first being the New York Real Estate Exchange. The creation of trade groups also coincided, perhaps not surprisingly, with the first appearance of agents being involved in lawsuits and mentioned in legal decisions. Now, during that initial period, and probably for the next 100 or so years, maybe longer, agents and brokers were considered sellers' fiduciaries, with no real duties or obligations to the buyers. This was the case even when other agents were contacted and utilized directly by the buyers for the purpose of finding real estate. In those circumstances, amazingly, the law considered those agents, the ones that the buyers were using, to be sub-agents of the sellers. And from a legal perspective, those agents still owe duties, fiduciary duties, to the seller, only limited duties, if any, to the buyer. Now, because agents and brokers were considered sellers' fiduciaries, in those early days of broker liability cases, the agents and brokers were usually protected by the doctrine of caveat emptor. I'm sure all of you have heard that term before. You know, it means buyer beware. That term, however, has become somewhat of a relic of a primarily agrarian society. Once society became more urban on a widespread scale, and in particular after World War II, when mass production of housing started to occur, the doctrine of caveat emptor began to sort of lose its grip. New doctrines like implied warranties of habitability, etc., took a bite out of the typical buyer beware sentiment that had previously existed. Then, in terms of consumer confusion, in 1982, the Federal Trade Commission report showed that there was widespread confusion about the role and responsibilities of brokers and agents in sales transactions. Significantly, while 72% of buyers and 82% of sellers believe that the cooperating broker, this is the agent helping the buyer find property, represented the buyer, the law hadn't caught up to that. They were still considered sub-agents of the seller. Given that modern changing attitude toward real estate sales, the move away from caveat emptor, some widespread confusion about the role of brokers and agents, there was an effort to regulate real estate sales, and in particular, agents and brokers throughout the country. I alluded to it before, property disclosure forms are now required in some form in most states, though not here in Massachusetts. Influential trade groups like the National Association of Realtors, the Mass Association of Realtors, also sought to impose ethical regulations on agents and brokers. Here are a few of the applicable mass statutes and regulations, some of which you may be familiar with already. The first two bullet points there are basically the standards of practice for agents and brokers. These regulations address conflicts of interest, prohibitions against self-dealing, agency disclosures, dual agency, concept that I'm going to come back to in a few minutes, and importantly, designated agency disclosures, which formalize the concept that an agent can represent the seller or an agent can represent the buyer. And once that's been addressed, the agent will owe that party fiduciary duties. We have the psychologically impacted property statute. I wanted to add this as a postscript to the Nathan for You clip. This is basically a shield, a liability shield to you all if, for whatever reason, you failed during the course of a transaction to disclose that a property was the site of a felony, suicide, or homicide, or that, and now I'm going to quote the statute, the real property has been the site of an alleged parapsychological or supernatural phenomena. Interestingly, these statutes are now actually in place in about 30 or so states in response to a pair of cases in the 1980s in which courts held that a seller owed a duty to disclose, in the California case, that the property was the site of a murder, and in the New York case, that it was a haunted house. Then we have 940 CMR 3.16 subsection 2. I point this regulation out, and I'm going to mention it throughout the day because it basically proclaims that a non-disclosure of certain facts by a broker or agent might be enough to trigger liability under Chapter 93A. This is important on many levels, but in particular, it is quite different than the common law principle that mere silence is not actionable. That's sort of your caveat emptor sentiment. And in addition, you as the broker or agent might actually owe a duty of disclosure where your client might not. And the main reason is that in most situations, if you are representing a non-professional home seller, the seller is not going to be subject to Chapter 93A, whereas you, as a professional acting in the business context, you will be. Private sale of home by a private seller is not considered to be in, quote, trade or commerce, which is a necessary element for liability under Chapter 93A. So in situations where a private home seller is not subject to Chapter 93A, this regulation here might require you to disclose something, like a latent defect, for instance, even though your client may not have that same obligation. So disclosing it could actually violate your duties of loyalty, confidentiality, and it might get your client a lower price, which would also present some issues for you as well. And so this is a good seg into a discussion about fiduciary duties. The fiduciary duties owed by agents and brokers include the duty to faithfully and honestly represent your client, to act with good faith and loyalty, to use reasonable skill to get the best price possible, and the duty to act honestly in good faith and to make full disclosure to the client. The classic statement on fiduciary duties comes from an old New York case written by a judge who went on to become a Supreme Court justice. And it states, many forms of conduct permissible in a workaday world for those acting at arm's length are forbidden to those bound by fiduciary ties. A trustee is held to something stricter than the morals of the marketplace. Not honesty alone, but the punctilio of an honor the most sensitive is then the standard of behavior. There are a host of situations in which fiduciary duties come into play in claims against agents or brokers. The most common is the breach of the duty of loyalty or self-dealing. One concept that historically raised self-dealing issues was the idea of net listings. That's essentially where the parties agreed to a minimum price and the agent received any amount over that minimum price as their commission. This created some incentives for the agents to get their clients to agree to the lowest price possible, which of course led to breach of fiduciary duty claims where the actual sale price resulted in a windfall to the agent. This practice is now, I think for obvious reasons, prohibited in Massachusetts and many other states as well. In Massachusetts, there have been some cases in self-dealing where the agent has had some interest or is attempting to obtain some interest in the property if they're involved on the buy side of the relationship as well, for instance. And in that regard, one hot topic that's been talked a lot about in the past few years is dark listings or pocket listings. And I know that the National Association of Realtors passed a regulation last year requiring all listings to be put on MLS within 24 hours of marketing to the public. But this regulation exempts into brokerage marketing. So it seems that this practice continues to occur, but it can present some real potential legal issues, especially for the larger brokerage houses that continue to use this practice on a regular basis. From a liability perspective, listings that are not aggressively marketed to the world can result in lower sale prices. And if that's the case, a possible breach of fiduciary duty claim from your client. Failure to disclose is another one that can sometimes result in breach of fiduciary duty claims. There have been cases where a broker failed to convey an offer to their client that has resulted in liability. In another case that I'm aware of, it was the failure to disclose the broker's ongoing business relationship with the buyer that resulted in liability. And then there's the issue of dual representation. To me, at least, the concept of dual representation is antithetical to the principles underlying theories of agency and fiduciary duties. That is, the idea that an agent basically serves one master and can therefore represent only one set of interests. But Massachusetts law specifically allows for agents and brokers to serve in these dual roles. so long as there's informed consent. But it's interesting. The applicable regulation states the following about disclosure, and I quote, "The consent form must state that a dual agent will not have the ability to satisfy fully the duties of loyalty, full disclosure, reasonable care, and obedience to lawful instructions, but shall still owe the duty of confidentiality of material information and the duty to account for funds." This disclosure language recognizes that tension, that inherent conflict in a dual representation scenario. If you owe one party a duty of confidentiality, you can't possibly make a full disclosure to the other party. So what happens when a broker knows about a latent defect? If you know about it and make the disclosure, you've likely violated your duty of confidentiality. If you don't, you've likely violated your duty of good faith and loyalty and possibly committed an unfair and deceptive act of practice under Chapter 93A. Next, we have fraud and misrepresentation claims. Let's start with the elements, and there are 4. Fraud requires, first, a false representation of a material fact. Second, knowledge of its falsity, or in the case of negligent misrepresentation, negligence. Third, reasonable reliance on the false statement by the buyer. And 4, damages. Now, silence is ordinarily not actionable as fraud, but this is far more complicated if there is a duty to disclose. For instance, if you are asked a direct question, you probably owe a duty to provide an accurate and complete answer. And then again, we have 940 CMR 3.16, which, as discussed, requires disclosures that could affect a buyer's decision-making process. Last, there we have half-truths. Once you speak on a particular point or topic, you have a duty to fully disclose all material facts with respect to that topic. This can sometimes come up based on conversations or statements made at an open house, and I've seen it more recently during virtual tours. There are far too many examples of misrepresentations that have led to lawsuits to list here, but I wanted to give you I think a fair representation of the types of more common examples that you see in the cases. You've got the size of the lot. There have been misrepresentations, claims based on inaccurate square footage representations. You've got surrounding area statements made that, for instance, adjoining property was conservation land and therefore not buildable. Could have a claim if it was in fact buildable. I've seen those cases. Water, in a quirky case that I was involved in a few years back, it was represented in an MLS listing that a home was connected to town water, but the connection wasn't actually a direct connection because it went through the neighbor's system. Zoning misrepresentations often involve buildability issues. Encumbrances, whether or not a right-of-way or an easement encumbers a particular property. Nuisance, this is the pig farm case I always think of. Buyer saw there was a pig farm next door. The broker gave the impression that it was permanently closed, but in fact it was not. And then noise. This one comes up a lot, particularly in mixed-use condo projects. I've actually seen this several times in the past few months in projects where there's a gym installed on the ground floor. So we've talked about what you can say or what you can't say. Let's talk about what you can say. In terms of permissible statements, there are 2 general principles to keep in mind, and they're up on the screen there. The first is false statements of opinion of conditions to exist in the future or of matters promissory in nature are not actionable. However, the line between what is a statement of fact and opinion is often shadowy. In construing what is the true meaning of the language used, it is often necessary to consider the subject matter, the relationship of the parties, the opportunity afforded for investigation and reliance, and the attendant circumstances. So the takeaway is that statements of opinion are generally not considered actionable, but the line is blurry. So, and I know everyone loves to hear this from lawyers, but in response to the question of what can I say, my response has to be it depends. So let's look at a couple of examples. For predictions, your property might sell for $100,000. That's a non-actionable prediction. Promissory statements. Hey, we'll work with you, or don't worry about it, we'll take care of it. Those are generally considered statements of expectation and are generally not actionable. On puffing, this basement is perfect, or these finishes are all top of the line. The roof is in great condition. That's all sort of puffing. And I want to read you a quote on puffing from a case that I absolutely love. The law recognizes the fact that men will naturally overstate the value and qualities of the articles which they have to sell. All men know this, and a buyer has no right to rely upon such statements. One of the thorniest issues that comes up in the agent-broker context is what happens if the broker just passes along information received from the seller. The general rule, as I alluded to earlier, is that passing along inaccurate or false information does not in itself create a cause of action against the agent or broker. But this general rule was clarified a few years back by the Massachusetts Supreme Judicial Court. The court basically held that this general principle is subject to a reasonableness standard. Basically, if you have a reasonable reason to consider that the information you received is suspect or possibly inaccurate, you have a duty to inquire further before passing that information along. In that SJC case, the court found that there was a duty to inquire further, where the seller said the property was zoned, quote, residential business B, but no such zoning designation existed in that town. That was a case out of Hingham. This topic also raises the question of disclosure forms. Most states with mandatory disclosure forms push them through due to the lobbying efforts of trade groups like the Mass Association of Realtors. And the thinking there is that these disclosure forms provide a level of insulation of brokers and agents from misrepresentation type claims. And oftentimes they do serve that purpose. But I will also tell you that I have a lot of residential conveyancing attorneys that come up to me and they ask, well, should I have my clients, the sellers, fill these out? My answer to them is always no, absolutely not. The more representations made by a seller, the more likely one of them could be cited as misleading or false in a subsequent dispute. Now, again, for agents and brokers, I think this fact raises another tension between you and your clients. Do you recommend that your clients fill out a disclosure form? It would certainly help you to have one that you could just pass along, but it could also open up your client to liability down the road. And in addition, as you all well know, could result in them getting a lower price. If you recommend a disclosure form and the seller in fact gets a lower price or gets into a dispute down the road, are you going to be potentially subject to a fiduciary duty claim? I think a lot of these problems, and quite frankly, a lot of home sale disputes in general, could be solved with mandatory disclosure forms. And I really think that Massachusetts should adopt them from a legislative perspective. Now, another question that always comes up is, well, what can we do to avoid fraud claims down the road? Is there anything from a drafting perspective that we can tell our conveyancing attorneys that we're working with? What that can mitigate the potential for these types of claims? Now, the answer to that particular question always starts and ends with your as-is clauses. These are your merger clauses in the P&S, your no reps and warranties clauses, etc. However, as-is clauses generally do not protect from intentional fraud. And this is for public policy reasons. Courts don't want to be in the business of promoting bad faith conduct. As-is clauses do, however, generally protect parties from negligent misrepresentations, because those same public policy reasons, not wanting to promote bad faith conduct, they don't apply where a misrepresentation was made just by mistake. I do want to point out that there are some situations in which as-is clauses might protect sellers and, of course, agents from fraud claims. But the factors to be considered are who drafted the provision, were the parties represented by counsel, was the clause open and conspicuous, what was the level of sophistication of the parties, and was the clause specifically negotiated. The other claim, of course, is Chapter 93A. In order to proceed with a claim under Chapter 93A, a party basically has to prove two things. They've got to prove an unfair or deceptive act or practice, and they have to prove that that act occurred in the context of trade or commerce. Now, there's no rigid definition of what constitutes an unfair or deceptive practice. Basically, if it falls within some concept of unfairness, if it's considered immoral, unscrupulous, you're probably going to be able to make a case that it's unfair or deceptive. The Attorney General has promulgated several regulations, which I think fairly summarize the field. And we have 940 CMR, Section 3.16. I put it all up there for you. And point 2 is the one that requires disclosure, I believe, of known defects. This is the one I've been mentioning throughout the day, and this provision applies to you all because you are working in the business context, and therefore you're operating in trade or commerce with respect to your transactions. So this is a thorny issue that you should at least be aware of, and if you have any questions, you should just ask an attorney about them. Because 93A, if you're tagged for a 93A claim, that could potentially subject you to punitive damages and attorney's fees. So it's a big potential issue. Lastly is insurance. Although agents and brokers are not required to carry insurance in Massachusetts, there are regulations that require insurance before the state will provide a broker license to a corporation or LLC. So as a practical matter, I'm sure that every one of you here has coverage. And so what does it cover? The short answer is that it covers liability arising out of professional services, meaning in order to be covered, the person must have been acting as an agent or broker at the time of the alleged error or omission. In other words, you must have been engaged in the sale, exchange, purchase, rental of real estate. This would include negotiations, tours, inspections, etc. The most common example of when the insurance applies would be when there's been a negligent misrepresentation made during the course of the sale. There are some common policy exclusions, and the most notable is for intentional acts. This exclusion covers intentional fraud claims. So if there is only a claim for intentional fraud, not for a negligent misrepresentation, the insurance company is not going to provide coverage. And in fact, they are probably not going to provide you with a defense in that circumstance. But if there's both an intentional and a negligent fraud claim, the insurance company is going to be required to provide you with a defense. And if they do so under a reservation of rights, in other words, if they say, hey, we'll provide you with a defense, but we're not going to guarantee that we're going to pay for it in the event you have a liability claim found against you. In the event they reserve rights in that manner, in Massachusetts, you can choose your own lawyer. You don't have to actually rely on the insurance company to assign their preferred panel counsel. The insurance company in that situation still has to pay your legal fees. It's a good thing for you to know. And then finally there's a difference between claims-made coverage versus occurrence-based coverage. I think they're somewhat self-explanatory, but basically under claims made, it requires that your policy be effective at the time a claim is actually asserted against you. And occurrence-based just requires that the event occur, whether it's a negligent misrepresentation or what have you, that that event occurs during the period of coverage. Now, the important thing to just be aware of is that you don't really want to mix and match these types of coverages because it can create gaps. And I'll give you a perfect example. I had a situation a few months back, I guess it was last year now, in which my client had claims made coverage one year and then occurrence based the next. The event occurred during the period when my client had claims based coverage, but the claim was reported during the period when my client had occurrence based coverage. So the insurance companies, the two different insurance companies, both refused to provide coverage or even a defense, and both were probably correct. I want to thank you all for your attendance. Again, my contact info is on the screen. If you have any questions after this, you can reach out to me anytime. As I hope you can tell, I love talking about this stuff, so don't think it's a bother. And Lauren, do we have time for any questions?
Yes, absolutely. So if you have any questions, now is the time to write them in your chat box. And it looks like we have one question already. Building lots, determining if actually a building lot or not. Can you say potential building lot?
Of course I have to fall back on my "it depends" answer, but the answer is probably yes. That's probably good enough. But I would, if I were you, I would probably inquire a little bit into that representation before I put it in an MLS listing. For instance, if there are some quirky zoning issues that affect the lot, maybe you want to, if you're working with a developer or something like that, maybe you just want to find out what their theory is behind why it's potentially buildable, if they would have to seek a variance. I would just be prepared to understand why it's just a potential buildable lot, because I think if you put that into your listing, you're going to get those questions, well, why is it just potential, or what can be built there? And I think under those circumstances, in order to avoid, that kind of half-truth issue that we talked about, you're probably going to have to give them some more information. So if you're going to put that into a listing, I would just want to just be a little bit informed about why it's just a potential, and then be prepared to follow up on that.
Next question. As an agent, should we get a seller's disclosure? Honestly, I'm still kind of confused about that question.
Well, it's a confusing issue. As an agent, I'd want them. And that's kind of one of the, I hope, takeaways for all of you from my presentation is that it would solve a lot of problems if there were mandatory disclosures in Massachusetts. We are sort of behind a little bit on that. Most states have them. And if they're mandatory, then, it doesn't require you as the agent to recommend it to your seller, because we all know that if something is disclosed in a seller's disclosure form, then there's the potential that it's going to impact your sale price, or there's the potential that your client is going to get sued down the road if it's not 100% accurate and the buyer is disappointed. So seller disclosure forms in general are great for agents. I think they're a positive for agents. They can provide a level of insulation to you all that you might not otherwise have. On the flip side, it's a tricky situation for an agent because you owe fiduciary duties to your seller client. It's tricky to say, hey, I really think you should, sign this seller disclosure form for X, Y, and Z reasons, because in the back of your mind, you got to be thinking, well, I know this is going to help me. And when that kind of tension occurs, it's really a thorny situation. I don't have a perfect answer for you, because they're good, I think, for agents. They're bad, I think, for sellers. And because of your fiduciary duties, that just, it creates almost an impossible situation. If this state were to mandate them, it would alleviate that tension. It would just be required, and you guys wouldn't be put into that difficult situation. And so, unfortunately, that's my answer. I think you should all go out and lobby the Mass legislature to require mandatory disclosure forms.
The next question is, do represent buyer and sellers as well as professionals?
Do I personally, or is that about insurance?
I don't know. If you want to, Keldra, if I think that's how you pronounce your name, if you want to send another message. Oh, yes, she says yes. He or she says yes.
I do a lot of representation of buyers and sellers. I get into these disputes all the time. I would venture to say 7 days a week, I'm dealing with these on some level. But the agent is always involved in these home sale disputes on one level or another. And I think that's the thing that you just want to be aware of, is that oftentimes, even though the issue is not necessarily caused by you, I would say 9 out of 10 times, the issue really has nothing to do with the agent. It's really more about the seller versus the buyer and what disclosures were or weren't made. But that invariably brings the agent into it, whether just as a witness or oftentimes as a direct defendant, which can implicate insurance coverage. So I think it's good to be aware of these issues. And I think that agents, because you are usually the intermediary, can probably prevent them on some level. But you definitely should be aware of them. And so that's I hope another major takeaway from today's presentation.
A common question from my agents is, should I review building department files prior to taking a listing, or ask my seller client to review the file to determine if building permits were obtained for certain projects?
Yeah. This is a reoccurring issue in my world, in the litigation world. And unfortunately, the answer is it depends again. If there is so for instance, if there is a new renovation or some special renovation that you're going to be marketing, if you're going to be playing up, they just redid this gorgeous kitchen, or they just renovated to put in, kind of like an open floor plan on the first floor. If that's something that you're going to be marketing actively, and it's going to be part of your MLS listing, and it's going to be part of your virtual tour or your presentation, I would say, yes, I would look into it. Because, you could just ask your client to do it, or you could ask your client just the basic answer, were building permits taken out? But your client, as you pointed out, may not know, and then I think you're going to probably have a duty to inquire further anyway. So if it's going to be part of your presentation, my suggestion is you probably should take a peek at the building jacket.
Should we not show the same property to two different buyers?
Should we not show the same property to two different buyers?
I think they mean if they're representing those two buyers.
Oh, if you're representing both.
Mhm.
Oh, that's that hasn't come up. Let me think about that for a moment. I don't see any problem showing the same property to two buyers. I think that you probably owe a duty to let the other buyer know, or to let both buyers know that you're showing it. Where it gets tricky is if both buyers want to make an offer. And I think that's where the informed consent piece of it comes into play. you've got to let the buyers know that, hey, if you guys both start getting into a bidding war here, I'm not going to be able to share certain information with you or make certain recommendations. So I think it can potentially be problematic. In and of itself, I don't think it presents a problem. But if you start getting into a bidding war where you're representing both, then I think it can present some problems.
Kind of similar. If you were an agent, would you practice dual agency?
I wouldn't. No. I mean, I understand the financial benefits to it for sure, but this kind of gets into the topic too of these pocket listings, which again is one of the, I know, hottest topics discussed in the real estate world these days. I wouldn't do it. I think that it's borderline unethical. I know that it's permissible under the law, but it raises so many issues. Now look, in my world, so there's a caveat here. In my world, where I'm dealing primarily with litigation, I'm always dealing with that 1 out of 10 situation that resulted in a dispute. And you may have experience where that's exactly what it is, where 90+% of the time you do dual representation, you don't end up with a problem. But it's that one time that you do that is a thorn in your side for 3 years, could potentially cost you money in legal fees, or it could, at a minimum, bump up your insurance premiums. And, you're going to spend time, emotional capital into litigation. So I think it's a risky scenario. From your perspective, depending on how often it happens, maybe it's worth that calculation. I myself think it's fraught with problems, and I do think it's risky. So my recommendation would be probably not, but it's a risk reward analysis that I think you have to conduct on an individualized basis.
If your seller client tells you something is not permitted, should you disclose that?
So I'm taking this to mean that if they're telling you that a certain use is not permitted, should you disclose that there is a certain use not permitted to the buyer? Again, this is where that regulation comes in, 940 CMR 316. And in particular, it depends on how you're marketing. So if you're marketing a situation, a use, something to that effect, or if you're saying, anything can be built here. I know that's an absurd example, but if you're saying something like that, that's broad-based, then I could see that having that information about, a non-use in the back of your mind could be a violation of that regulation and of the half-truth doctrine. So I think in that situation, you should disclose it. But I could also fashion a situation where you're just throwing, like in an estate situation where you're just putting the property out there as is. And you know that there is a certain use that's not permissible. But I think under certain circumstances, you're not required to do that because it's sort of obvious, if it's a residential neighborhood or something like that, a business use is clearly not going to be permissible, or at least an industrial use. So I think there are certain circumstances where you're not going to have to do that, but sort of the devil's in the details, as with every lawyer's answer that you'll probably ever get in your lives.
They actually followed up with it and they said, no, they put in a new kitchen and did not get permits.
Oh, I've had this situation. That is not a good situation to be in for an agent. I think that, especially if you are putting, marketing these renovations, for instance, I think you gotta tell them. I think you ought to, at a minimum, it could create some major problems down the road, even if not actual liability. So I think you're really walking a fine line in that situation. That is a dangerous situation. And I always, my philosophy is that, more disclosure is better because it avoids situations down the road. If these folks put in renovations without getting permits, there was probably a reason for that. Maybe they didn't want their taxes to go up. Maybe they were, using, who knows, some unlicensed professionals to do it. And if that's the case, then some additional investigation needs to be done, and those permits should be taken out in some fashion. Or number two, these renovations need to be priced accordingly. And so that's how you're going to avoid the situation down the road where whether there's actual liability in front of a judge or jury or not is almost a secondary issue. Because if something were to happen, if there was a collapse issue or if a gas line leaks and there's a fire or an explosion, whatever the situation may be, that's going to be a situation that's going to create so many problems for you down the road. So, I'd love to chat with you offline about this. That's a very, very difficult situation for you to be in.
Actually, Jeanette, if you'd like to put up Bob's contact information, that slide, that would be great right now. We have a couple other questions. How do you as a seller, oops, my chat went away, hold on one second. How do you as a seller, children of original owners, know if it is an estate sale versus the children already owning the property?
Well, that's a good question. I wish I could ask a follow-up there.
So this was Mary Beth. She says seller agent.
Mary Beth, why don't you reach out to me offline? I think that's a good question. I think with a couple of additional questions, I might be able to at least get you closer to an answer.
Actually, I just allowed Mary Beth to talk.
Oh, great.
So Mary Beth, if you would like to voice your question.
Sure. Can you hear me okay?
Yep.
So if you're representing a seller and the parents have passed and they had an arrangement that the house was to go to the children, but you're not sure if that happened, that took effect already, or sorry, it's hard to be kind of clear, but how would I know as an agent where the ownership lies when I am asked to represent that person?
Yeah, I mean, the easiest way is you could do a little bit of research on most of the registry of deeds, have that information posted, and you could probably find out through that. You could call a lawyer that could have a paralegal do that type of work as well. But I think to kind of I suspect what you're driving at is, well, should I treat this as an estate sale or not? And actually, I don't necessarily think that I don't think that it matters who the actual owners are at the time, whether it's the children through like a deed process or a trust process, or if it actually has to go through the estate process. If you're marketing it as an estate sale, like as is and etc., I don't think it matters. Now, from a title perspective, the lawyers are certainly going to have to figure that out because, it has to be sold according to whatever the law authorizes. If it has to go through the estate process through the probate court versus if it can just be kept out of the estate, that's something that the title and closing attorneys will figure out later on down the road. But for marketing, I think that the fact that the kids don't live there, that the parents live there, that the agreement essentially was to sell it. I think that to me speaks that it's more of a, an as-is estate sale under that situation.
Thank
And
you. And as is a state sale, is that a disclosure that has to be listed somewhere in the listing?
Personally, I think it would. I mean, I know it lowers the value, but I think it's just it's useful to your clients, because if they haven't been living there and they don't have an intimate knowledge of all of the inner workings of the home, if you're making it clear that it's sort of an as-is estate sale in the marketing materials, I think that provides some level of insulation to your clients and, quite frankly, to you, in that home, sale dispute process. But it does lower the price. There's no question about it. The developers are going to be on the lookout for it, and people that are looking for a easy move-in ready home are probably going to shy away.
Thank you. Very helpful.
You're welcome.
so the next question, do you anticipate an increase in lawsuits or threatened lawsuits with buyers waiving inspections?
Not an increase in liability. I know that's not a direct answer. I'll back into the answer. I think when you waive inspection, I think that gives a level. That's one of those provisions in an offer and P&S that I would probably broadly consider as is provisions. If you're waiving a contingency and then you're going to complain about something that you could have figured out obviously from an inspection, I think you've got a tough road home in making that claim in front of a court or an arbitrator or a jury. That being said, I've seen a number of these already. They've as you pointed out, since the pandemic and kind of this recent explosion in home sales, in order to be competitive, people are waiving these all the time. And when you have less information, whether it creates a cause of action or not, you're getting buyers that are less satisfied with the sale process. And, a lot of times they feel like, hey, if we waive the contingent, the inspection contingency, then that means that, the property's perfect and the property is, exactly as advertised, 100%. Or my agent's to blame. My agent told me that there should have been an inspection waiver here, and I'm going to blame my agent. So the answer is, I don't necessarily see an increase in liability, but yes, I do see an increase in claims.
When an agent makes a statement in the MLS as to the fact that buyer's agent and buyers need to verify info, how much weight does that have?
It does have some weight, actually. And, perfect example is on the disclosure form, that sort of typical, the standard disclosure form in Massachusetts. Actually, it might even be the Mass Association of Realtors form. But that form at the top of it says, here's all the information, but buyer must verify that information. I mean, I've used that very language in briefing materials to fight against fraud claims several times. So I think the answer is, yeah, it's helpful. Anytime you make a representation, but you're qualifying it in that manner, I think it's useful. Doesn't mean that you're going to avoid a lawsuit or liability. Maybe not, but it's a darn good argument to have in your back pocket.
All right, well, that looks like all the questions that we have for today. We had a lot of really great questions. So as a reminder to everyone, this webinar has been recorded and will be available to view in the next few days on our website at marealtor.com. You can find it under webinars in the green archive section, and you can find any upcoming webinars on that page as well. Also, if you want to reach out to Bob, again, his contact information is on here. You can go ahead, take a screenshot, write down his information. Before you close your screen today, you'll see a survey. If you would like to fill that out, we appreciate your feedback. We also have a broker webinar at 1 p.m. today, also on liability. So we hope to see you then too. But thank you so much, Bob and Jeanette, for your presentation. And thank you for everyone for joining today. We hope to see you
Thank you,
next
Lauren.
time.
And thank you all for the great questions and for listening.